Good afternoon, everyone. Welcome. My name is Alyssa Gresh. I'm the Director of Programming for the AAJLJ. Thank you to everybody for joining us today, and thank you to our very esteemed panelists who I'm about to introduce. This is Comparative American and Israeli Public Corruption Jurisprudence, and we have today with us Abbe Lowell, Richard Horowitz, Yaakov Roth, and our moderator from the AAJLJ and Struck and Levon, Mark Spicer. And thank you to everybody for joining the AAJLJ and participating in our programming. It's really a pleasure to see you all. And we do have some upcoming programs. We have our upcoming Pursuit of Justice Awards, which you'll be hearing about very soon in May. So please stay tuned and thank you. And we're going to get it started with Mark Spicer.
Hi, good afternoon. Thank you, Alyssa. I want to briefly introduce the members of our outstanding panel today. First, we have Richard Horowitz, who is admitted to the bar of New York, Washington, D.C., and Israel. He's a former officer in the IDF and has lectured extensively on corporate espionage, money laundering, and related topics. We also have with us Abbe Lowell, who is the co-chair of the White Collar Regulatory Defense and Investigations practice at Winston & Strawn, LLP. Abbe has represented numerous high-profile clients, including Senators Robert Menendez and John Edwards. He's also represented Senior Presidential Advisor Jared Kushner and is currently representing Hunter Biden. And then we have Yaakov Roth also with us. Yaakov is the partner in the Issues and Appeals practice at Jones Day in Washington, D.C. At the Supreme Court level, he has represented Bob McDonnell, former governor of Virginia, and Bridget Ann Kelly, former aide to New Jersey Governor Chris Christie. We're going to start with a brief introduction by each of the panelists, a brief statement, and then we're going to go into a panel discussion. So, Richard, we'll start with you and take it from there. Thank you.
Mark, before Richard gets started, we're also going to have a Q&A in the last 15 minutes. So if you'd like to ask questions, please write them in the chat and we will get to them, hopefully. Thanks.
All right, thank you, Mark. I'm going to make a number of observations about Israeli criminal law, comparative Israeli public corruption law. First, I'm going to talk about the following things. First, that I think there's a problem with criminal statutory drafting that you wouldn't find in the United States. Second, in Israeli bribery law, it's not talked about that much in the commentaries, but you'll see that in Israeli bribery law, a gift is presumed to be a bribe, so people are convicted on the presumption that a gift is a bribe. Third, there's a breach of public trust statute in Israel, which does not exist in the United States, and I'll go into detail on that. And fourth, I think that Israeli judges, for a reason that I'm not able to fully explain, but I think Israeli judges take certain liberties with legal reasoning that you wouldn't find in the United States courts. But I think maybe I can just, and the last point I'm going to make, which hopefully we'll get to, is I think, as surprising as it may sound, I think one of the fundamental differences between Israeli and American public corruption jurisdiction is that Israeli law is based on fundamentally British law, because that was the law that was present at the time in 1948, but it's based on the European notion of what a right is, as opposed to an American notion of a right is. And that's something that I'll get into hopefully later on. Just for example, the Constitution of the Kingdom of Saxony of 1831 said that there's religious freedom only for Christians. Now that concept of a right cannot be the American concept that a right is self-evident and inalienable. And I'll talk about more contemporary European documents, but I don't think there is any other country that has the American notion of a right. And let me just speak to the criminal drafting statute issue first, because that won't take long to explain. the Israeli criminal code, and it has, keep it in mind when you hear about the public bribery statute and the breach of trust statute. The Israeli criminal code, last I checked, has about 504 statutes, and a lot of them are written nicely. Some say whoever does any of the following is guilty of the following crime, and they list it. But many of these statutes are one sentence long. And in America, certainly the bribery statute and the breach of trust statute are less than 10 words. The operative wording is less than 10 words. It's whoever takes a bribe, whoever breaches a public trust. In America, obstruction of justice is not the statute. It's Chapter 73 of the criminal Title 18. In Israel, the statute is whoever obstructs justice. And I think I understand why that developed. And for those who don't understand the Hebrew, please forgive me, but I think it's based on Mishnaic writing, because in Mishnayos you have Chovel b'chavero chayav b'chamisha dvarim, hamafked etzel chavero b'hamakalim, hameniach esakad b'shusar rabim. You have he who does the following, and the following isn't described in the Mishnah. That's why there's Gemara, Rashi, Tosfos, and lots of other things. But in the Israeli statutes, you have the same style. Whoever takes a bribe, whoever breaches public trust, whoever obstructs justice, that's the crime. And that lack of definition, I think, is problematic. The breach of the bribery statute in America, the relevant bribery 18 USC 201 is over 100 words. The witness tampering statute in America is thousands of words, and those words, bribery and witness tampering, aren't in the statute. You're in the heading of the statute. In Israel, the statute is 10 words, and whoever tampers with a witness, whoever takes a bribe. So I think that's a problem in statutory drafting. But
Thank you.
that's my introduction.
I think we'll go now to Abbe, and then we'll get all these for his statement, then Tia.
Thank you all. I think the way I can start is by making sure everybody recognizes and understands that pursuing investigations and cases of public corruption has been, is, and will be a priority of prosecutors in the United States, no matter what party is in office, and no matter what officials run the Department of Justice or their equivalents in state and local governments. And in a way, that's the way it should be, because if the system of government is corrupted, then it affects every other decision that government makes. And so it's always been a priority, even though some administrations will also prioritize healthcare fraud, and then others will do environmental, or others will do financial institution. Public corruption is the constant. Also, in the United States, there are 3 levels of prosecutors that look into this. There's federal, state, and local. And they're all getting more and more powerful. And if you needed an example of that, everybody is paying close attention to the local prosecutor in New York City's Manhattan borough to see whether that's the office that brings the first case against former President Trump, alleged to occur this week, perhaps, based on a very interesting set of theoretical charges that we don't know yet. Fourth is, all of this underscores not only just federal and state and local laws, but in the United States, we have this overlay of campaign violation laws, and each legislature and executive branch has ethics rules that overlay. And so there are all kinds of minefields involved in pursuing or investigating or defending in public corruption. The next point people should consider is that prosecutors are ever always more creative in coming up with even more ways to apply law, as they did, for example, in the John Edwards case, and they might in the Donald Trump case, in which private affairs turn into campaign contributions, or most recently, the new shiny toy in the arsenal is the Foreign Agent Registration Act, which people are using in the public corruption arena. With all this said, it is not completely within the discretion of prosecutors because, as Yaakov will point out later, the United States Supreme Court has taken the lead in putting the brakes on the ever expansive nature of public corruption investigations with 4 decisions that started with cutting back on this vague notion of what's called honest services to the most recent example in the Kelly case, which people know as Bridgegate, which addresses the issue of what is a property right and how prosecutors have to confine themselves to the words of statutes. All that said, the challenge in representing public officials in the United States is what I just said, but also keeping into account that public officials, when you represent them, may be running for re-election, may have to answer to their constituents, have the ability to be thrown out of their office by way of impeachment or other ethical considerations. And it creates a multiple level of the requirement for strategy that takes into consideration the law, the politics, the public relations, and all the things that don't happen when you're representing an individual. And so in the United States, as I said, and to summarize, this will always be a priority. And however, as prosecutors keep pushing the envelope, interestingly enough, it is our United States Supreme Court, which has lots of different political perspectives, who on these most important cases have ruled unanimously to cut back some of these pushings.
Thanks, Abbe. And that was a great introduction to the observation that I wanted to share just at the outset, one high-level observation, and then we can get into the questions. And that is, from my perspective, we really have 2 different regimes of political or public corruption jurisprudence in the United States. We have political corruption cases in the Supreme Court, where we have seen a lot of emphasis, dating back now at least 30 years, on due process, on having clear rules, on ensuring that there remains political accountability, and that the criminal laws aren't used to criminalize ordinary political behavior. Those considerations are sort of front and center when the Supreme Court is deciding these cases. And that, I think, is where we're going to see the most contrast with some of the points Richard made about the jurisprudence developing in Israel. But there's also political corruption jurisprudence in the lower courts and in sort of everyday, indictments and criminal trials and so on in the lower courts of the United States, where I think the picture is quite different. Of course, they're bound by what the Supreme Court says on legal questions, but there are a lot of real-world considerations that I'm sure Abbe is going to be speaking to as well, that shift the dynamic. And, for example, it's very rare in the United States for a district court to dismiss an indictment pre-trial. It happens once in a while, but it's very rare. Courts are very reluctant to do it. And so the consequence of that is even aggressive political corruption theories, aggressive theories of how to read these statutes, can get before a jury in the district court. And then courts of appeals are very deferential to jury verdicts. So if the jury convicts a defendant on one of those aggressive theories, the courts of appeals are generally not very, they're not readily looking for legal ways to overturn the verdicts. And so we have a much more permissive system in the lower courts than we do when cases make their way up to the Supreme Court, and we're looking at sort of the creation of broad prospective interpretations of the statutes, which tend to be much more favorable to the defendants. So that's just a high-level observation. I'm sure we'll get into some of the details a little more later.
Okay, thank you, Yaakov. So first, we're going to ask, when we talk about political corruption, we usually think of bribery. Presumably, bribery is illegal both in the United States and Israel, but I wonder how much commonality there is under the surface. Richard, what are the defining features of a bribe under Israeli law?
Well, you have a statute that says whoever takes a bribe is subject to the following penalty. But in Israeli jurisprudence, a bribe can be presumed, a gift can be presumed to be a bribe. Right? And that's not spoken about much. There have been endless commentators and and the reports about the Olmert cases. When I was listening to the Olmert cases in the news, I'm thinking to myself, I don't understand the quid pro quo. Endless commentaries on who said what and at what time. And then I read in the introductory section a 2-page section called Chizkat HaMuda'ut, which is a presumption of knowledge or a presumption of awareness. And it turns out that at least the earliest case I saw in Israel is in 1993, where the court states that based on common sense and logic, someone dealing with a public official who gives a bribe, the gift is considered a bribe. Now, problem with that, 2 problems. First of all, nowhere in those case law does it explain how this presumption of knowledge can override the presumption of innocence. Right? So there was a book published a few years ago in Hebrew on bribery, a 500-page book, very good book, comprehensive book. When it came to this question of the presumption, there was 1 page on it. And all the author wrote was the presumption is based on common sense and life experience. And he couldn't write anymore because there's nothing else to write because the case law doesn't get into it. So the Israeli regime of public corruption jurisprudence is basically the bribery statute and the breach of trust statute. So bribery can be presumed to be a gift. And so a gift can be presumed to be a bribe. Now I'll give you one example of a minister how this is applied. He was accused of bribery, indicted on bribery, but then he got Knesset immunity. He was indicted on bribery because his financial advisor suggested that he suggest an amendment to some law that deals with the financial industry, which he did. And he was indicted on bribery because what he got in return for suggesting that law, according to the prosecutors, was that he got the services of his financial advisor. Where's the pro in the quid pro quo? There isn't one.
Yeah. So, Abbe, is there any presumption like that in the United States? Oh, you're on mute.
I was trying to be respectful. There are no presumptions in criminal law generally, and not in the bribery and corruption laws in the United States. And indeed, there's a formula that a prosecutor has to prove beyond a reasonable doubt, which is the highest level of proof in the American judicial system. That may be different in Israel as well. And that, as already has been talked about by Richard, requires the government to prove in a bribery case that there was something called a quid pro quo, a Latin phrase in which the quid talks about the things of value that was provided to a public official. And the quo is what did the public official do in return? The government has to prove that there was an agreement between the person giving and the person receiving, that they will take that gift or thing of value in exchange for doing something. It is a burden of proof that is not hard, depending on whether or not you have a cooperating witness, like the person giving, but often it is a very hard. And what the courts have also said in the United States is, if in the context of a campaign contribution, we're talking about this quid pro quo, the proof that a prosecutor has is even higher and has to show that that agreement was an explicit agreement. And to make matters even more complicated in the United States, much time prosecutors can use a fallback to the bribery requirement, which is another form of offense here called gratuity, which is really one that talks about gifts. Everybody in the United States will understand what a gratuity is, because everybody in the United States, well, that's not true, but a vast number of people in the United States give public officials a gratuity every December when they put $25 in an envelope in their mailbox to give to the post office person who delivers the mail. That is giving somebody a gift for what they've done in their public office. That, if it was seriously more, would be a gratuity. And so in the United States, a gratuity does not require a quid pro quo. It is generally said it's a thank you for a public official doing something, and the gift is given on account of the public official doing that. theoretically, you could even give a gratuity before the public official gives it, but mostly it is after the fact. So there are no presumptions, but there are these formulas that a prosecutor has to prove beyond reasonable doubt.
Thank you. Yaakov, are there any other important constraints on bribery prosecutions in the United States?
Yeah, so the other one that I would draw attention to, and going back to the quid pro quo, so far we've talked mostly about the pro, the exchange element, but at least over the last number of years, there's been an increased focus on the quo element, which is what is it that the government official has to do in exchange for the gift or bribe in order to satisfy the statute. And at least for the federal official bribery statute, which is 18 U.S.C. 201, it's referred to as official action. So you give something to the public official, and the official in exchange takes official action. In the case that you mentioned in the introduction, the McDonald case involving the former governor of Virginia, the question of what constitutes official action made its way to the Supreme Court for the first time in about 100 years. And the theory in that case, the prosecutor's theory in that case, was that the governor had accepted gifts from a businessman and in exchange had done things like introduce him to other people in the government, invite him to a party where he could meet and network with people, those types of sort of what we would think of as political courtesies. And the government took the position that that was sufficient to qualify as official action. And the Supreme Court unanimously rejected that and said, no, official action requires some sort of nexus to the actual exercise of government power, right? Some sort of real government decision or action that is either being taken or that the official is pressuring another official to take. But you need to have that connection to the sovereign power in order to fall within the scope of official action and the bribery statute. And that is also a very important limit on bribery prosecutions now in the United States, because in order to put the whole case together, the government needs to really link up the gift or thing of value that's going to the official with a concrete action that is being taken in exchange. Now, I'll just want to add one thing, which is going back to how I started. In reality, it's, sometimes they can evade both of these limits through facts and sort of the type of facts that juries tend to think are sinister or corrupt, even though they're actually not really satisfying the legal test. So I'll just give one quick example. It's a case I worked on involving an individual businessman, a retired government official who struck up a friendship with a congressman, and they were close personal friends. They would go out to dinner together regularly, socialize with families, definitely had a genuine and long-standing friendship. And this individual was wealthy, and he would give he would help out his friends with money all the time when they needed help. Not just the congressman, all his friends. I mean, he was sort of known for being very willing to give gifts, and he did help out the congressman and his family on a few occasions. And so the government's theory was those were bribes. The government said those gifts were bribes. So what did he do in exchange? What did the congressman do in exchange for this person? What they came up with was he had written a letter of recommendation for the person to be an ambassador. In other words, he sent the president a letter saying, my friend so-and-so would be a great ambassador. Now, if you think about the elements we've been talking about, the agreement, right, the concrete government action, it's hard to see how those are satisfied here. But, juries don't necessarily feel very positively towards rich people giving congressmen gifts. And so the jury convicted in that case. Now, we were able to get it overturned on appeal, but the point is the real life day-to-day prosecutions sometimes can go forward despite these limits.
Well, that's an interesting point about how these concepts and defenses play with a jury. Richard, is there a right to a jury trial in Israel? And how are most corruption cases tried?
Well, let me just comment on what Yaakov and Abbe said. The Israeli bribery statute says whoever takes a bribe regarding something in connection with his job, which is very general language. So there is no distinction between official act and non-official act, and there is no distinction between gratuity or bribe. It's all covered under that 7-word statement. In Israel, there is no jury system and there's no grand jury system, which a lot of Israelis don't recognize. I mean, I can understand why, but so you in Israel you have one government legal advisor or state prosecutor convicting, and you can have one judge on the panel. State prosecutor or government legal advisor indicting, and then you can have one judge convicting. And I think that's too much power for two people. I mean, that's one of the reasons we have a jury system, that the government isn't judge, jury, and executioner. So the jury system is a limitation on the power of the judiciary. So you have two government employees, or I mean, significant employees, government legal advisor, state prosecutor, and one judge indicting and convicting.
Well, it sounds like a major procedural difference. Abbe, you've tried countless public corruption cases to juries in the United States. Can you tell us about some of the considerations that you need to account for in that context? Oh, you're still on mute.
Sorry, I apologize. I won't do that again. It is a major difference in the two countries, as you just heard. Let me start with a little tidbit that people probably don't understand. People in this country don't understand. Everybody in this country knows you have the right to have a jury trial if you are a defendant. You can claim you want it. What people don't understand is that you don't have the right not to have a jury. By that, I mean, if a defendant doesn't want a jury trial, wants a judge, and I'll come back to that in a second as to why that might be, if the prosecution objects, then the defendant doesn't have the choice. And people don't necessarily know that, which is kind of interesting. There are times, very few times, maybe minuscule times, in which a defendant in a public corruption case would want a trial by a judge. And that would be if the public official involved is so disdained, so already disliked, that there's no chance that a jury will apply the law that Yaakov has talked about, for example, in what is required for an agreement or what the quo has to be in terms of an official act. They'll just not like it or like the person. That said, the major difference that we're talking about is, goal number one in a criminal trial in the United States for a defendant is an acquittal. Goal number two is a hung jury. And you can get hung juries by having just one person say they are not going to go along with the other 11. And while that's not the ideal, because often that case will be retried, both in cases that I've done where there was hung counts, when we found out that the vote was 11 for acquittal and 1 for conviction, or 10 for acquittal and 2, the government has decided not to retry it. So I can give you 2 examples too, in terms of why juries matter. In the case against Senator Menendez in New Jersey a few years ago, the government's theory was that a man who the senator had known for over 20 years, been to family events, been to the equivalent of bar mitzvahs, been in funerals, been at weddings, and had exchanged all the gifts that you get, had bribed the senator after all those years by giving him not money, not cash, not check, not jewelry, but allowing him to stay at his house in the Dominican Republic and sometimes flying him there on his private plane in exchange for the senator taking this man's position with federal agencies dealing with medical regulation. Why a jury was good in that case was that jurors would understand that a person you've known and have been in those events for 20 plus years is not likely somebody you could bribe. And therefore, the theory of what's a quid pro quo actually worked better in front of a jury than it might have in front of a judge. And a second example is the case that I tried representing former Senator John Edwards, who was charged with campaign violations for having his friends provide things of value not to the campaign and not using his campaign, but having his friends pay the woman with whom he was having an extramarital affair while he was running, the same theory that might be used against former President Donald Trump. What was good, and it's especially important in the setting of this webinar, is that my opening line in the closing argument to a jury, which you might not be able to do to a judge, was my getting up and saying, ladies and gentlemen, this case stands for the proposition that there's a difference between a sin and a crime. And all the prosecution has proven was that there was a sin. You wouldn't do that in front of a judge, but you can do it in front of a jury.
I'd like to comment that doesn't work in Israel because of the presumption that the gift is a bribe. And just in terms of speaking of a quid pro quo, the Israeli way of saying a quid pro quo in the Hebrew of wording of a quid pro quo is shitat ten v'kach, the give and take method, right? And the give and take is the quid and the quo. So the question jumps out at you. I mean, we all know that you have to prove every element of a crime. So the question jumps out at you. Quid pro quo has 3 elements, and the give and take method has 2 elements. How do you prove a crime of 3 elements with a method that only relates to 2 of the elements? And the answer is they rely on the presumption that a gift is a bribe. Now, in the States, you can infer from common sense and logic that a gift is a bribe, but you've got to justify an inference beyond a reasonable doubt. In Israel, you only need to rely on the presumption that a gift is a bribe, and you don't have to work too hard in order to rely on a presumption. And the judge in that Holy Land case wrote, after his 2 pages of analyzing this presumption, which is, as I said, sometimes the Israeli judges take liberties with reasoning that I can't explain. He actually wrote, what he wrote is, after explaining the presumption, this is not to say that we are transferring the burden of proof to the defendant, who can always contradict it by raising reasonable doubts. That's exactly what a presumption is, but that's what the judge said. And I should also say, in an interview after the judge retired, he actually said that no public official should take gifts. You don't even need a law for that. You don't even need a law for that in a criminal matter. There's no criminal law that prohibits taking gifts in Israel. But
Well, that makes me think about what other procedural differences exist in how corruption cases are investigated and charged in the United States. And Yaakov, who runs corruption investigations in the United States, and how does that impact defense strategy?
Sure. Well, here in the U.S., every judicial district has a U.S. attorney who is appointed by the president, confirmed by the Senate. I'm speaking, by the way, about the federal system. As Abbe said, there's also state and local prosecutions. But at the federal level, you've got U.S. attorneys in each district who are often the ones running a corruption investigation. But many of the higher profile cases are actually run, at least in part, through the main Justice Department or main justice here in DC, and they have a group within the criminal division that focuses specifically on public integrity. It's known as PIN, or Public Integrity Unit. And they'll often work with the local U.S. Attorney's Office on particular prosecutions in this area. Now, what's interesting about that, and I'm sure Abbe can speak more about how this affects strategy, is that if you are a potential defendant, if you're being investigated in a corruption investigation in the United States at the federal level, you can generally appeal internally at the sort of executive administrative level, all the way up through the Department of Justice, from your local U.S. Attorney's Office to the PIN folks in DC, up to the head of the criminal division, and in theory all the way up to the Attorney General, to ask them to reconsider what they're doing, whether it's at the outset of the case or, sometimes this happens after a court decision or a hung jury and they have to decide whether to retry, and ask them to sort of take a broader look at how their theory or their approach is going to impact the law and impact other political actors. So sort of goes to Richard's point about having a lot of discretion in just two people. Here, there's quite a lot of people who you can seek review from and ask to exercise discretion in a particular case. Again, Abbe probably has more specific examples.
So with that invitation, I will give you some examples. So this is an example of what's possible theoretically and what's happening practically. Theoretically, a line prosecutor who could be 32 years old and maybe have never worked in business in life and has only been in law school and in the government decides that she has the best case that's ever existed in public corruption. And then you could go to that line prosecutor's immediate supervisor, who might be a little bit below the level of what Yaakov was saying as the public integrity unit head of section, and make your case. And there you might have some success. You might be able to say to such a supervisor, this is a stretch of the law, or the evidence isn't there, or this is the cooperator is going to be destroyed in a court of law, etc. However, let's be clear that you can still go above that person to the head of the public integrity unit, and you can go to the head of the criminal division, and above that is the deputy attorney general. I'm talking in the federal system, and above that is the attorney general. But here's the way it really works. If a line prosecutor and the section decides that a case exists, in a case in which we're talking about a public official of any notoriety, the odds that the higher-ups will say, nope, we're not bringing the case are somewhere between 0 and 15 or 20. And the reason is that by the same nature of this public official being high profile, if somebody high up squashes the case, there will be all kinds of furor on the opposite side of the political party that this was done for political reasons. And people higher up in the Justice Department don't want to use their political capital for that, when they're dealing with so many other things that they need to use their political capital for. That's particularly true, and I'll go back to the two cases I mentioned before. The case that was brought against Senator Menendez, which was a stretch based on there being a friendship of 20 years, and the case against former Senator John Edwards, where the Justice Department started a new theory of corruption in that theory of what is a political contribution. So in both cases, I was hired just before the case was indicted. And in both cases, I tried to go up the line to tell the higher-ups that this was a bad case for various reasons, the two I just told you about. When it got to the highest levels, remember, in the Justice Department, you had a Democratic Attorney General and a Democratic Deputy Attorney General, and I was asking them not to bring a case against two Democratic senators. And in that situation, it would have been far better if the Attorney General and the Deputy Attorney General had been Republicans. Because you can imagine the furor if the Democratic Attorney General or Deputy Attorney General said, you're right, this is a bad case, I'm not going to let it go forward. And the next thing that would have happened is that all the lower downs would have leaked it to the Washington Post, it would have been on the front page, and there would have been heck to pay. So yes, there's the ability to procedurally seek review, and that's great in theory. But in public corruption cases, public officials don't get the benefit of that review as often if you were a private citizen where a line prosecutor was coming up with a new theory of prosecution.
Okay, now turn to substance. Richard, in some of the news stories about political corruption investigations in Israel, they refer to an offense called breach of trust. What is that crime exactly?
Breach of trust is a statute in the Israeli Criminal Code that says whoever breaches the public trust shall be sentenced to no more than 3 years. It's been. I'll take one statement that a judge said in the Supreme Court in the Talansky case. He referred to a 2004 case that said that case in 2004 put an end to the debate about whether the breach of trust statute is vague. Because how are you supposed to know what to do if it only says don't breach the public trust? In fact, a retired state prosecutor actually said at a conference that he doesn't think breach of trust is vague because public officials are forewarned to act with integrity. In effect, what it means is it's criminalizing, it's legislating morality or criminalizing appearance of impropriety, and that's a hard thing to. So where does the breach of trust statute come from? You look into the 2004 case, the Israeli case, and the court cites Stevens' book, Stevens' Digest of the Criminal Law, British book, 7th edition, 1926. The first edition, I think, was in 1877. And that is word for word the Israeli breach of trust case, meaning the Israeli breach of trust statute, meaning whoever breaches the public trust. Difference is the only thing the Israeli statute left out is in the Stevens book, it shall be a misdemeanor to breach the public trust. In the Israeli statute, the penalty is 3 years. So the question jumps out at you. Why is the Israeli court pointing to a secondary source? Who was Stevens and why is his book so important? And whoever he is, why is the Israeli court referring to a secondary source as the source of Israel's breach of trust statute? Why doesn't it refer to the parallel British Criminal Act for the source of the breach of trust statute? And the answer is because breach of trust was never codified in Britain or the UK because it was found to be too vague. It started in a case from 1783 where an accountant failed to report, in that old British language, he wickedly and willfully and maliciously failed to report that certain people weren't getting paid, and the court came up with a crime called breach of public trust. And that's the source of the Israeli statute. Now, so happens that, and in the Israeli jurisprudence actually says it portrays breach of trust as a sort of a general intent crime. It says the defendant doesn't have to know that what he's doing is breach of trust. He just has to know that his physical acts constitute what will be considered a breach of trust. And the next paragraph says, breach of trust is not a specific intent crime. Now, if you look at general intent crimes here in America, they're assault, rape, and kidnapping. Everybody knows what that means, but nobody knows what a breach of trust is. It can be applied to anything, and I can give you examples. The same case, the 2004 case, says that Israeli yesh lihimana milatet le'sif hafarati monim perush mitzantzem. Israeli courts should be careful not to give breach of trust a limiting interpretation, meaning it should be given a broad interpretation, which is against American jurisprudence. And it happens to be that in the Israeli Penal Code, there's a statute that says if there's more than one interpretation, the one that's most lenient to the defendant should be the one used. So I don't know how the court reconciles the fact that that statute says what it says. Jump to 2020. And after several years of analysis, the UK Law Commission published a book, a report, Reforming Misconduct in Public Office. And it's a several 100-page report and with several appendices. And the report says, breach of public trust, though important as the rationale for an offense, is likely too broad and uncertain a concept to be a defining element of any particular offense. At the very least, any new offense should contain more precise definitions of both the types and the harm covered by the offense. And regarding Stevens, they're referring to what he wrote, his original edition, 1877. It says, the report says, it is in fact clear that Stevens gave little consideration as to the definition of the offenses collected under the heading of breach and trust of others. Indeed, Stevens stated, quote, of the offenses defined in part 3, which are those offenses, I have little to say. Most of them are common law offenses of rare occurrence. Now, in Israel, breach of trust, I can give examples, but breach of trust is applied to things that you could not foresee. And it's one of the staples of the Israeli public corruption jurisprudence, and that would never happen here.
I guess, yeah, Yaakov, do we have any similar concept to breach of trust in the United States as a crime?
Well, it's interesting. It actually reminds me quite a lot of something that Abbe mentioned earlier, which we refer to here as the honest services concept or doctrine or statute. And there's a bit of a history there that I have to explain. But originally, there's been a statute prohibiting bribery of federal officials for a long time. But the way most state and local officials were prosecuted for bribery was originally under the federal fraud statutes, mail fraud and wire fraud. Now, mail fraud and wire fraud historically were really about tricking people out of their money or property. But starting in the 1940s and then expanding significantly in the 60s and 70s, lower courts in the United States came up with this idea that people have a property right to honest and faithful service by their government officials. And this became known as the honest services doctrine. And so people would be criminally prosecuted for mail fraud or wire fraud on the theory that by taking a bribe or by paying a bribe, they defrauded the public of their right to an official's honest services. Now, that concept, like breach of trust, is very malleable and subjective. What are honest services? What does that include? And indeed, there were many examples of courts using that language and stretching it to prohibit lots of political conduct that they consider to be dishonest in some way. Now, that state of affairs lasted until the late 80s, when the Supreme Court finally reviewed this theory in a case called McNally and said, this is not within the scope of the federal fraud statutes. The federal fraud statutes are about property. They're not about good government. But just about a year later, Congress enacted a statute, and it's only 28 words, Richard. So it's not that much longer than the ones you were referring to in Israel. It just says, for purposes of this chapter, the term scheme or artifice to defraud, which is the term of art from the fraud statutes, includes a scheme or artifice to deprive another of the intangible right of honest services. So they essentially tried to recodify the same vague, open-ended concept that had been developing in the lower courts and that the Supreme Court had rejected. And it took another 20 years or so for the Supreme Court to consider that statute and to hold in the case best known as Skilling, that you can't actually apply that the way it's written, because it would be too broad and unclear and raise all sorts of due process concerns, because we don't know what the intangible right of honest services even means. And the way they fixed that problem was to say, we're just going to read that to mean bribery and kickbacks, because that, they said, was the core of the original theory. So I guess my answer is, we sort of did have a situation where we had a vague, open-ended statute like the breach of trust statute, but the Supreme Court has largely dealt with the problem by reading it very narrowly.
Okay, that's good. And one of the tensions in corruption law is between judicial remedies and political remedies. And in the United States, public officials can often be removed from office for defined violations in carrying out their jobs, for example, through impeachment. Abbe, how do these procedures impact public corruption and interface with ordinary criminal proceedings? Because we're seeing this over the last year, we've seen quite a bit of this.
Indeed, all. So a couple of points I made. Let me start with what I said in the introduction, which is that the many layers in the United States in which people can be held accountable for their actions, which turn out to be a form of public corruption. So Yaakov pointed out what was going on in terms of prosecution. Remember what he was saying, though. These were not state and local prosecutions being brought by state and local prosecutors. This was state and local public officials being prosecuted by the federal government. One of the reasons that the Supreme Court's been cutting back in the cases I mentioned and the cases that Yaakov mentioned is this notion of federalism, which is that the state and local governments ought to be allowed to operate in what is unique to them without the federal government prosecutors applying their standards if the state and local prosecutors have not. But that goes right to your point as well, which is that in local, state, and federal prosecution, public officials, there are, in addition to the criminal laws, campaign laws. So a campaign or its official can be sanctioned by the Federal Elections Commission. It's not a crime. They can make the reference, but they can bring a big case civilly and administratively for a big fine. That could also become public enough so that the world will rise up against that public official and ask that public official to resign. We'll see how that works in a case that everybody's reading about in New York for a Republican that was elected on Long Island named George Santos, who it turns out is, I don't know, probably some person other than George Santos. But there's that. But there's also, therefore, the institution. The House of Representatives in the Santos case has ethics rules and procedures, and they have the ability to expel a member for various ethical violations that may or may not rise to the level of being a crime, that they might. Indeed, mostly, I think it would be weird and odd and probably yelling and screaming outrageous for a legislative body to throw somebody out for conduct that at least wasn't at the margins, if not in the mainstream of being a crime. But they have the ability to discipline, and that discipline can go to censure, removal from a committee, or expulsion from the legislative body. And then, of course, there are on the federal level for presidents, judges, and even cabinet officials, the ability for there to be formal impeachment proceedings. Now, that's a whole different kettle of law, because the questions on the presidential level, everybody knows the standard now, because while we had only one impeachment proceeding for most of the United States history, in the last 30 years, we've had 3. So it's changed, but that's something called high crimes and misdemeanors. Notice the word crime and the word misdemeanor is in that constitutional standard, but it doesn't mean violations of a criminal statute or a misdemeanor statute. There's a whole body of law of what it does mean. From the time in which the Republicans in the Clinton impeachment decided that if you lied about having an affair, you have committed a high crime and a high crime or misdemeanor, to the Congress in the Trump administration that said a phone call to a foreign official in which you're suggesting that he or she bring an investigation against your political opponent could be a high crime and misdemeanor. And so on the state and local level, the ability to remove a public official is even greater in terms of even things like recall. So there's, in the United States, probably 5 layers of enforcement against public officials beyond the criminal prosecution. And that also may be a profound difference in Israel.
Thank you. I guess now we'll turn, we have a few minutes left to Alyssa, if there are questions for the panel.
Yes, we do have a few questions. Some of them may have been addressed. So we have one question. Thank you, first of all, for this engaging program from the person who asked the question and from the AAJLJ as well. Some of the panelists appear to favor the American jury of your peer system. Is there research to support the notion that the jury system is more accurate in its outcomes? Does justice prevail more in a jury system?
Who is that directed to, Alyssa?
Probably all of us. It's a very big
Yeah.
question. I mean, Abbe tries and wins cases in front of juries, so he's probably partial to the jury system. But I'll let him speak for himself. I tend to handle appeals, so I get involved when the jury's made the wrong decision and have to get it reversed by the Court of Appeal. So I'm not a huge jury person.
It's complicated for whomever asked that question. There's not one size fits all. I just think that most criminal defense lawyers in the United States, including those that are involved in public corruption cases, as I said before, we have 2 big doors that we can try to walk our client through. The first is an absolute acquittal, and the second is a hung jury. And depending on the nature of the case, I would say that way more than 9 times out of 10, maybe 9.3 or 4 times out of 10, the jury system is what's going to be preferred by people here. And is it more accurate? Well, the problem is we don't know, because all those cases we're talking about, McDonald, Skilling, Menendez, Edwards, were all tried in front of juries. I don't know what the outcome would have been if they had been tried in front of a judge and the judge was asked whether it's too much of a stretch or there's not enough evidence. So I guess the answer to the person who asked the question is, we'll never know.
And I'd like to make one comment. I think when the founding fathers wrote about the trial jury and grand jury, their thinking wasn't what's more accurate, the jury or a bench trial. Their thinking was juries, grand jury and trial juries are a way of limiting the power of the government. So.
On this point, I'm not a criminal lawyer, but I've served on 2 criminal juries, and I was impressed by how people try to get to the right answer. I was really, until I served 2 different times on a criminal jury, I thought, but people really try to find the facts, and they go through it, and it was, for me, it was quite revealing and impressive.
That's common. You'll hear that a lot, that juries take this very seriously. Yeah.
I think we can take a couple more questions if you guys don't mind staying 5 extra minutes. We can probably get some more, but so I'd like to ask, this is for Abbe, are the US standards same for attempted bribery, for example?
Well, not exactly, because for there to be a bribe, as I've pointed out, there has to be proof beyond reasonable doubt of an agreement, and there has to be proof beyond reasonable doubt that an agreement entailed a quid pro quo. So it's the kind of crime, unlike bank robbery, where you can get into the car, have a gun, drive up to the front door of the bank and change your mind, where it still could be an attempted, depending on how far you went. There's not really an attempted bribery here. It would have to be like, I asked the public official to do something, and then the public official, I didn't really give him anything. I was thinking about giving him something. So you see, it doesn't work in that regard. I think that what the questioner is asking probably fits into the category that an attempted bribe might fit into the category of a gratuity. But remember, for either of those to occur, you're going to have given the public official something. And one of the things that Richard has pointed out is this interesting concept in Israeli law, where the giving of a gift to a public official is presumed to be a bribe. As I said, in criminal law in the United States, having a presumption against the defendant would be unconstitutional. So consequently, there's not likely the attempt here in this statute as there would be in others.
You do have, though, I agree with that, of course. But you do have some interesting questions that come up sometimes when the agreement is alleged to have not been fully formed. So you have a situation where there's an offer to give something in exchange, and the theory might be the person offering it intended it as a bribe, but the public official accepted it, didn't realize it was a bribe. And so you could have a bribery prosecution on those facts, even though no final agreement was actually formed, if that was the intent of the donor, I think. But there's that came up, for example, in the Shelley Silver case in New York. That was part of the theory, at least on appeal. There's some interesting hypotheticals.
I think one thing to add, Yaakov, on that, and you're absolutely right, is one more point. And I think this is maybe goes to the questioner. The public official does not have to carry out the event. So I can go to the public official and say, I'm going to give you all expense paid trip to so-and place or any other thing of value if you'll vote on favor of my bill, or if you'll get me something that the Supreme Court has decided is an official act. The public official says, I'll do it, and never does it. It's a bribe, because you don't have to accomplish the event for it to be a bribe. And that, in that sense, it's kind of like an attempted crime.
I think we'll take one more if that's okay, and then we'll close. So this morning, U.S. Deputy Secretary of State Wendy Sherman summoned Israeli Ambassador Herzog And here's your statement. The Deputy Secretary conveyed U.S. concern regarding legislation passed by the Israeli Knesset rescinding important aspects of the 2005 disengagement law, including the prohibition on establishing settlements in the northern West Bank. They also discussed the importance of all parties refraining from actions or rhetoric that could further inflame tensions leading into the Ramadan, Passover, and Easter holidays. Do you have any thoughts on that?
I don't have any. So, you know, I don't have anything relevant to the presentation of that.
One thing that question might actually raise, and it could be a subject for a whole different webinar. As we look at the debate in Israel that the government is seeking what they're calling reforms to the process of the judiciary and the controversy it's created in Israel and in the United States, especially among the American Jewish community. I think one of the things that Richard said that we should pay attention to that's really fascinating is that so much of what I have talked about today occurs because we have something called the Bill of Rights, which has a number of features, including what people have said, the due process of law. And that also comes to having a constitution that tells the executive branch what it can do, the legislative branch what it can do, and the judiciary what it can do. And what we now know, I mean, we maybe lawyers here knew, but what the public now knows is that Israel doesn't have a constitution, doesn't have a Bill of Rights. So much of the protection, again, for criminal defendants in the United States come from those two documents. And that's really something that's very different between the two countries.
Yeah, I'd like to just to comment on that, tying in Israel to the European system of what a right is. In the Bill of Rights, fundamentally, except maybe Article 6, because I don't think it could have been worded any differently, the Bill of Rights are limitations on the government power. They say the Congress shall pass no law, there shall be no unreasonable search and seizures. In European constitutions, the rights are announced. Everyone has the right to this or that, and then subject to the following limitations by law. So no sooner does the European system announce you have a right than it's limited by law. Now you would think laws are subject to the Constitution. Constitutional rights aren't subject to laws. But the American system was developed in order to create a system of rights, and rights are limitations on the government power. In the European system, the power structures existed for sometimes centuries before the modern nation state with the contemporary sort of constitution was created. And the power structures that be didn't want to give up the power. So the laws are announced. You have these laws subject to the following limitations. In America, there was no power structure to give up anything because it didn't exist until America was created. So there was nothing to give up. So in the European constitutions, and I've reviewed dozens of them, you have these announcements of rights subject to the law. In America, and those aren't limitations on the government power to advance certain noble ideas that are subject to the law. In America, which may be the only country, rights are, the constitutional rights are limitations on the government power. And you see that type of European language in the Israeli human dignity law, which I suspect we don't have time to get into now, but I wanted to mention that because I think fundamentally, if that was studied more deeply, I think that would explain a lot of the difference between the Israeli system and the American system, because after all, British law was the law before Israel was established, and most of the Jews who established Israel were European. So why the surprise that it should accept or adapt the European notion of what a law is?
Thank you so much. I think on that note, this is going to be a good place to close. Thank you again to our esteemed panelists, Yaakov, Richard, Abbe, and Mark for moderating, for taking the time out of your undoubtedly very busy days to join us. This has been recorded, so as long as nobody objects, we will circulate the recording to the people who registered for this program. And just one final thing before we go. This is from the AAJLJ. We have Rhonda Lees, our VP, would like to make a quick announcement on our Pursuit of Justice Awards from in May.
Okay, thank you, everybody. This was fabulous. We are honoring 3 amazing people on Wednesday, May 10th at 6 p.m. in DC. Invitations forthcoming. One of them is Akiva Shapiro, who is a partner at Gibson Dunn in New York. The second is Eli Rosenbaum. Gosh, what can you say about Eli besides all the work that he's done at the Department of Justice? And the third is Janice Boyarsky-Schiff, who is an attorney here in DC at Holland Knight. So we're very excited about the variety of people. POJ is always the highlight of the season, next to, of course, today's event. And it's an opportunity for us to support the AAJ, keep us going, and listen to some pretty amazing people, and networking, and of course, completely kosher food. So more on that later. Thanks for letting me talk.
All right. Thank you. Thank you again to all. Have a great day.
And we look forward to seeing the attorneys again in the news. So thank you for your work.
Yes.